A prescriptive easement gives its holder specific limited access to someone else's property due to long-standing use, typically of something like a driveway. Prescriptive easements and adverse possession are established by similar elements, including the sometimes perplexing notion of a claim of right, the subject of Felgenhauer versus Soni. In 1971, Jerry and Kim Felgenhauer bought a property that contained a restaurant. Behind the restaurant was a parking lot belonging to a bank with a public alley behind the lot. Over the years, the Felgenhauers alternated between operating a restaurant and leasing the space to other businesses. Delivery trucks came up the alley and through the parking lot to the restaurant's back door. The Felgenhauers never asked the bank's permission to let trucks drive through its parking lot. In 1984, the Felgenhauers sold the restaurant business to James and Ann Enlow. The Felgenhauers kept the real estate, which they leased to the Enlows. Delivery trucks continued to drive through the parking lot. In 1988, James Enlow spoke to a bank manager in the parking lot. The manager said the bank was planning to build a fence between the bank's property and the Felgenhauers. Enlow asked the manager to install a gate so deliveries could arrive and the restaurant would have access to the dumpster. The manager agreed. In 1998, Ken and Jennifer Soni purchased the bank property. At this point, the restaurant was owned by William DeCross. The Sonis informed DeCross that they were planning to cut off access to the restaurant through the parking lot. The Felgenhauers brought an action to quiet title to prescriptive easements over the parking lot. The jury found that the restaurant had used the parking lot continuously for 5 years, between 1982 and 1988, without the bank's permission. This established a prescriptive easement for deliveries. The Sonis appealed to the California Court of Appeal. They argued that the restaurant's use of the property wasn't under claim of right.